just two quick questions about the Myriad case in particular to start us off. Just two things I don't get about what's happened recently. One is that I read that after the decision, Myriad's stock went up. So I don't get that.
No.
Was that false?
Yeah, I don't think that's correct at all.
Well, then that was easy.
Well, so here's the detailed facts. It went up until noon, and then it started dropping, and it dropped down to the 26 range from the 32 range, and it's gone up a little bit. I actually haven't looked. I should look. I'll give you an answer in a minute. So why did it go up? Because stock analysts the week leading into it had been reading the announcement saying buy Myriad stock, and the press release that Myriad released right after the thing happened was CDNAs are affirmed. And we still have all these other claims that we have, and those are the basis for the current lawsuit. So the stock analysts were reading an optimistic report from Myriad, and it was later in the day that the stock began to drop as other news stories and Ambry and DNA Traits and University of Washington announced that they were going to enter the market. Then the stock analyst said, oops, maybe it's going to go down.
So this has been seen as bad news for Myriad on the whole. Right.
Right now, I think it's extremely volatile and up to people's interpretation of what the future of the business is going to look like.
And my second question that follows on is that the argument that genes can be patented if the sequence in the patent application is not what's found in nature because the non-coding bits have been left out. That is, in terms of this debate, ancient. It was well articulated in the 1980s. I believe it was actually used to justify some of the early patent applications. Why does it seem to be such a big deal now?
Help us, Amanda.
Why is it a big deal?
It's just ancient. Intellectually, it's been not just sort of around and well understood, but well discussed and used. I just don't understand.
In terms of what? In terms of biology? In terms of
genes?
Yeah. So I'll hazard a guess. So look, this whole concept of a gene, look, the literature in our field for the last 2 decades has been, we don't know what a gene is anymore, right? It's fuzzy. We acknowledge that it's a fuzzy boundary. But look, what's in front of the Supreme Court is a very simple decision. They got 2 things they're worried about. Francis Collins and Harold Varmus and Eric Lander are telling them, we're really worried that patents are getting in the way of whole genome sequence analysis in science. So they're worried about if you can allow people to patent things that are far upstream in R&D, you're going to be able to block research. On the other hand, they're also hearing from all the companies, the majority of the amicus briefs were from companies that were worried about upsetting the apple cart. And they don't want to upset billions of dollars that have been invested in biotech companies, premised on being able to patent a gene in order to produce a valuable therapeutic protein, for the most part. So at that end, they have cDNAs. And what they said is, we think that's patentable and that's not, and that's all we have to decide. So they haven't actually bought into any particular vision of the gene. They haven't bought into any particular vision of whether it's a human gene or a non-human gene. All they said is, this is the case in front of us. We've drawn a line here. Don't ask us how we decided that. I'm just telling you what we decided. And I think it's smart that they didn't say why, because as soon as they start saying why, they're setting precedents that are going to have unintended consequences.
Sorry, Robin, you can come in on this?
Yeah, I was just going to say very quickly, this is a little bit anecdotal, but I ended up on the train down in Washington with a intellectual property lawyer just as this case was being discussed in 2009, 2010. And he was just immediately dismissive of the ACLU suit. And it speaks to the fact that in terms of how these patents are usually litigated, the type of questions that the ACLU suit originally raised just aren't usually on the table. Right. You don't usually have litigation in the United States as to whether or not something is patentable. It's who controls the patent. It's sort of like the nuclear option that no company would ever take. So I think part of the lag is simply the novelty of the fact that it was a public interest suit.
Yeah.
It's not there.
Yeah.
There's a question.
So thanks for this very interesting session. I also wanted to go back to this point about the cDNA, because I see your point about them being smart in not creating the president. On the other hand, this argument about cDNA patentable and the genome not patentable is clearly implausible. in the sense that, but I think that it's interesting in the way in which it tells us about what nature is for the Supreme Court in this case, because they're saying that this is not occurring in nature, and of course this is true if you think that the cDNA, meaning the complementary DNA, in that order that exists in nature. But of course, we are all interested in that molecule in terms of its informational content.
Yeah.
And the informational content is patently coming from nature. If you were in nature, we wouldn't actually be having this discussion because it would be useless. So it seems to me that the nature that the Supreme Court is sort of carving out is a nature that emerges from the manufacturer, and that's why I found your point very relevant. Except that, again, if we look at manufacturing, I mean, are we making a hierarchy between the role of the reverse transcriptase as an enzyme, which counts as non-natural, and the role of the restriction enzymes that you need to actually isolate and purify the DNA, which are of a lesser rank? I mean, if nature becomes dispersed in terms of the kind of manufacturing and craftsmanship operations that you need, then where are we left then?
Good question. Where are we?
For Brian, maybe?
Oh, I just completely agree with that point. I think that those are exactly the kinds of very fine distinctions that become very unsustainable or very difficult to make in that setting. And, you know, I am troubled by their concept both of nature and of manufacture, of which, you know, and how you would characterise these different elements. But as Bob said, I think an argument has been made that there has been a kind of, you know, technique for capturing this information, as we talked about last night at dinner, and, you know, that is deemed as some sort of sufficiently inventive act. But, you know, whether or not that holds and whether that sustains in comparative industries, you know, you can think of other lots of software, you know, examples where the same thing is achieved, but doesn't attract the same kind of form of protection. So, I don't know, you may have thoughts on that.
So your point about if and in the Supreme Court's decision, they do make an argument that the reason that the DNA stuff is so special is that it's the embodiment of information. That was Judge Sweet's. DNA is the embodiment of genetic information, and that's what makes it special. It's a storage and transmission medium for genetic information. And so the Supreme Court has made an informational argument, but of course you're absolutely right, it's an incoherent. If your criterion for applicability of that concept in this context is the information content, then there's no difference between cDNA and gDNA. Except, think about it, in the diagnostic context, there's a huge difference because many of the mutations are going to be in intervening sequence, splice junctions, stuff like that. So to have a diagnostic test, you have to use genomic DNA, period. And so it solves that problem for them. It doesn't solve the problem of how much do you have to change in order to make it an invention. That's the silent question here. And it can't merely be the information content. There's got to be something else going on. We don't know what's in their heads. And we're not going to know what's in their heads until we have another case.
I've not got a lot of time. Have we got time for one quick question?
You've actually got 10 minutes. We have copious time. But that was a brilliant question.
Hi, thank you for the talks. And I'm curious about something that I didn't see as much of here, which is jurisdictional differences, so different jurisdictions, and the move of a lot of genetic research and biotech in places like India or China. And I'm just curious what you have to say about this. It's a very sort of softball pitch. Could you comment on jurisdictional sort of differences and how that would affect your considerations here? So I guess a variant of this, I was thinking this silly joke, if a variant of a tree falling in the forest doesn't make a sound, if a patent was put on a gene and somebody in India doesn't pay any attention to it, is it really patented? So I guess I don't know who wants to take that.
Right, okay. Patent law in India is, in terms of biotechnology, is such that, I'm just trying to think, I think I was looking at Article 3D of the India Patent Act. The Act has been in the news just recently because there have been some big cases in India concerning access to essential medicines and the interpretation of the India Patent Act and whether they allow second medical use and all this sort of thing. The criteria for patentability, TRIPS mandates minimum standards, but it doesn't specify what those standards are. So what is the standard for novelty? What is the standard for inventive step? And India has, as a developing country, developing country as defined by the UN, has incorporated into its patent laws quite a deal of flexibilities that are provided for under TRIPS, not as much as Brazil. Brazil's patent reforms are sort of going forward at the moment, and they incorporate virtually all of the flexibilities under TRIPS. But India's act is stricter, I think, than the US and the EU in terms of novelty. So if the thing is not novel, if it is natural, you can't patent it. So in terms of DNA, there hasn't been a case litigated as far as I'm aware. But it is my understanding that DNA, isolated DNA, is not patentable in India. Does that answer your question?
Well, so a couple of other jurisdictional differences, though. In Brazil, the statute is pretty clear that genomic DNA would not be patentable. The people that I've talked to in the Brazilian Patent Office say it's not always applied consistently, but that's what the statute would imply. In the biotech directive, clearly that you couldn't get the result that we got in Myriad under the biotech directive.
No.
So, but now it's going to be up for review. Who knows what's going to happen? And we've got this case in Australia that has gone through the district court and reached the opposite conclusion from Judge Sweet, which is that DNA is patentable because it's an artificial state of affairs. And that's going to now be appealed, and who knows what's going to happen at the appeals level in Australia. So this happens all the time. You have different jurisdictions that apply the same criteria and reach different conclusions with different factual backgrounds.
And even the Supreme Court, just recently, has actually arrived at a completely different conclusion about patentability of gene sequences compared to the Court of Justice of the European Union. That was actually under the criteria of industrial application, rather than, is this thing inherently patentable, or is it, a discovery?
There are questions, all right?
Yeah, I have a question, but I really, I have problems with this product of nature. In the sense, if you come from a slightly constructivist position in science studies, let's say, I mean, are we happy then to define a DNA sequence as a product of nature? So when this case study is forward, and we have someone now, you need to work in amicus brief and always updated us on all this. I was really worried about this argument. I hope that it would come out not patentable, but I was so worried about this argument because I just have problems with calling it a product of nature, because we would not in science studies call it a product of nature. It seems to me that Robert maybe you can answer that.
Well, so I think that's exactly right, and so this is actually what most of the amicus briefs were really worried about. And what are they worried about? They're worried about vitamin D, vitamin B12, insulin, antibiotics, things that are vaccines, things that are found in nature that have been patented, and it's kind of been established since Park-Davis in U.S. law, which turns out to be a big mistake. This is a nice use of history that actually made it Supreme Court. John Harkness's article where he went back and discovered that Learned Hand had kind of screwed up the Park-Davis case. That's kind of cool. So it actually mattered maybe a little bit in this case. But we can't possibly take the product of nature stuff that seriously. And I don't think that the biotech folks have made all these parade of horribles. The Supreme Court is, in deciding this case, is going to screw up everything else for antibiotics and all these other future products that are analogous to that. And I don't think that's true at all. I don't think the Supreme Court's going to have a problem at all when you're producing a product. Back to what Bronwyn was saying. If you've made something, streptomycin or insulin, and you've turned it into something that obviously doesn't exist in nature in the form that's useful in the way that it is now, I think they're going to figure out a way to say, yeah, that's across the line. That's an invention. It's okay. It has been made by man. But when what you're doing is creating a service to produce in the test tube the exact same sequence of a molecule in order to find out whether somebody's body has a mutation, that's a different thing where all you're doing is making the molecule in order to extract the information from a person's sample. That's diagnostics, and that is not made by man. I don't think it's hard to make that distinction. I don't think Supreme Court or anybody else is going to have. A lot of patent lawyers are going to have trouble with that, but I don't think most people with common sense are going to have trouble with that distinction.
Again, obviously, just talking about different jurisdictions arriving at different decisions. To the Mayo case, the Mayo and Prometheus case, yeah. There's been the decision of the Enlarged Board of Appeal that is the highest appellate court at the European Patent Office, sort of equivalent to the Supreme Court, if you like, has decided the opposite to the Mayo case, and that such an invention taking the measurement for purposes of diagnosis and then administering a drug is actually patentable. This thing does confer novelty, it is patentable.
Can I just make a quick reaction? Just in response to this point about nature, I mean, I think the discussion highlights the fact that when we're talking about something about nature, it's a nebulous concept. Depending on your sort of perspective, you're going to come to a different interpretation of what that means. I mean, if you come from a constructivist perspective, you'll have one interpretation. I mean, another interpretation might be that we talk about availability in nature. If not in nature, where is anything available? I mean, everything is available in nature, and all our innovations are available in nature. There's nothing exists outside nature. I mean, and that might be a way of justifying some sort of extremely radical view that nothing we do is unnatural. I mean, it seems to me this just points to. I don't know whether these problems are intractable or insoluble, or we're just not sort of sufficiently cognitively equipped to work out what the answer is. But I mean, I think this just points to the kind of difficulty underpinning cases such as these.
I agree, and I think one of the things that I take from environmental history and some of the other discussions of the tragedy, like the so-called tragedy of the commons, which is sort of in the background of this, is that creating a commons which is apparently freely available and natural is always a political and economic act. In the same way that with bioprospecting, what parts of that are included as part of nature and therefore outside of concerns of patrimony. So I think very much in this case, there's there's a new set of line drawing with patent lawyers. Think is all realize it's a radical change in sort of some of the alignments they've been proposing, but it is very much like using the idea of nature to make a commons that is the product of the court's reasoning and not like grounded in any representation or reality of nature as such. And I'm sure that different jurisdictions and debates will sort of flesh out where those boundaries are drawn.
Okay, so I'm very conscious that 3 of our panelists have to get on a plane in about an hour and a half, so we're really going to have to wrap up exactly on time. I make that just 1:30. So you'll join me in thanking our panelists for one.